Hello and welcome my students. Today's subject for discussion is Women's Rights under the Statute Law. To start with, various rights are conferred for the benefits of the people, both by the constitutional law and the ordinary laws. These ordinary laws, other than the Constitution, are known as statute law. Statute law means a law passed by the competent authorities or a ruling body and enacted formally by following prescribed procedure which is incorporated under the Constitution. The examples of statutory laws are the laws made by the Parliament or the state legislatures within the permissible limits as being set by the Constitution. Not only the Constitution, but the ordinary statute laws confer rights to the people called human rights. And human rights are those minimal rights which every citizen must have against the state or other public authorities by virtue of his being a member of the human family. When we talk about human rights of women, they shall include like the rights to equality before the law, the right against gender discrimination, the right against harassment, the right to privacy, and the right of economic empowerment, etc. The Protection of Human Rights Act 1993 has defined the term human right. The term is defined as the rights relating to life, liberty, equality, and dignity of individual guaranteed by the Constitution or embodied in the international covenants and enforceable by the courts in India. Applying this definition to the women's right, it may be defined as the rights of women relating to life, liberty, equality, dignity, as are conferred by various statutes, that is, enacted laws other than the Constitution. So, in this study, the matter shall be confined to women's right under statutory laws of India, including the criminal law and procedure and other recent statutory laws that guaranteed rights to the women for upliftment of their status. The right to life and liberty of free movement. As far as this right is concerned, the right to life cannot be deprived of except in accordance with the procedure established by law. One of the ways by which this right to life can be deprived of is by abduction of a woman, meaning thereby that whoever by force compels a woman by deceitful means induce her to go from a place is said to abduct that woman. Abduction is an offence under the Indian Penal Code 1860. The abductor is punishable for imprisonment and also with fine or with both. But when a woman is abducted, the first necessity is to find the woman out, and then the next step is to cause the wrongdoer to punishment. In this regard, the Code of Criminal Procedure 1973 provides the power to compel restoration of abducted females. Section 98 of the Criminal Procedure Code provides that upon complaint made on oath of the abduction or unlawful detention of a woman or a female child under the age of 18 years for any unlawful purpose, a district magistrate, a subdivisional magistrate or magistrate of the first class may make an order for immediate restoration of such woman to her liberty or of such female child to her husband, parent, guardian or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. This is a statutory provision enacted for the women who are abducted and for setting them at their liberty. This provision is akin to the writ of habeas corpus that can be issued by the High Courts or the Supreme Court under the Constitution. The statutory right as conferred by Section 98 of the Code of Criminal Procedure 1973 is more easier to avail of than the writ of habeas corpus, as the executive magistrates are closer to the people within their districts and easier and less expensive to avail of their services for restoration of abducted females than to go to the high courts, which is too technical, expensive and cumbersome. Next is trespass to person of a woman, which assumes use of tremendous force in case a man commits the offence of rape as defined in section 375 of the Indian Penal Code 1860. An intruder or a wrongdoer is punishable for the commission of this offence to the maximum of life imprisonment and with fine. The statutory right of equal treatment of women with her male counterpart under the law of the succession is another aspect. For an instance, equality before the law and equal protection of the law is a fundamental right of every person in India. The Constitution came into force in 1950, but the Hindu Succession Act is passed in 1956, which laid down the rule of equality between male and female heirs. After coming into force of the said act, it has become a statutory right of a Hindu woman to enjoy equal right with the male heirs in the matter of succession of intestate properties. Under section 8 of the act, the general rule of succession in the case of males is that property of a Hindu male intestate shall be devolved first upon the heirs specified in the class 1 of the schedule. Under class 1 heirs, daughters, widowed daughter of the predeceased son, daughter of a predeceased daughter, widow of a predeceased son, daughter of a predeceased son of a predeceased son, and widow of a predeceased son of a predeceased son are all equally to inherit the intestate property of a male Hindu. It is not out of place to refer to the right of an unmarried woman to adopt a child under the Hindu Adoption and Maintenance Act 1956. This is statutory right of an unmarried woman to have a child by legal fiction of adoption. The child so adopted shall for all purposes be treated as the child of the unmarried adoptive woman as its mother. Next is the statutory right to economic empowerment of women. Friends, in India, women are by and large economically backward. This economic backwardness of women has been noticed by the judiciary in a number of cases, that rights of economic empowerment of a woman is a human right of woman. Statute has been met by making the right to economic empowerment is the right of women. only recently the Parliament of India has passed the National Food Security Act 2013, wherein Chapter 6 is the provision under the caption Women Empowerment. The scheme of the Act is that the eldest women who are not less than 18 years of age in every eligible household shall be the head of the household for the purpose of issue of ration cards. Where a household at any time does not have a woman or a woman of 18 years of the age or above, but has a female member below the age of 18 years, then the eldest male member of the household shall be the head of the household for the purpose of issue of ration card, and the female member on attaining the age of 18 years shall become the head of the household for such ration cards in place of such male member. In case of payment of food security allowance to such household, the allowance shall come to the hand of such head who is a woman. Thus, women will be empowered to manage the household by enabling them to use the money by their decisions, management and discretion. The Act envisages nutritional support to pregnant women and lactating mothers. It has been the statutory right of women under the Act that every pregnant woman and lactating mother is entitled to meal free of charge during pregnancy and 6 months after childbirth through the local Anganwadi to meet the nutritional standard under the Act. Further, such women are entitled to maternity benefit of not less than 6,000 rupees. The benefit is not entitled to the employed mothers in the government and public sector undertakings. Now, statutory right against sexual harassment. For a long time, the law of sexual harassment was only a decisional law of the Supreme Court, but the Parliament of India made it a statutory right of women in India and brought out the Criminal Law Amendment Act 2013, by which sexual harassment has been made a statutory offence by inserting the provision in the Indian Penal Code 1860, wherein besides the offence of sexual harassment, certain other acts affecting the women folk are made punishable. Section 354A is newly brought in. It is provided that a man committing any of the following acts shall be guilty of the offence of sexual harassment. They are: first, physical contact and advances involving unwelcome and explicit sexual overtures, or secondly, a demand or request for sexual favors, or thirdly, showing pornography against the will of a woman, or making sexually colored remarks. Sexual harassment of the nature of unwelcome physical contact and advances, or a demand or request for sexual favors, or showing pornography are the acts punishable with imprisonment, which may extend to 3 years, or with fine, or with both. Sexual harassment of the nature of making sexually colored remark is punishable with imprisonment, which may extend to 1 year, and with fine, or with both. Besides, the Criminal Law Amendment Act, by which the act is made punishable, the Parliament of India brought the Visakha guideline of the Supreme Court in a statute book called the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013 to protect every woman from any act of sexual harassment at workplace. The term sexual harassment is defined exactly as defined in the Criminal Law Amendment Act 2013. The term workplace is also defined in all-inclusive term as any department, private sector organization, hospitals, nursing homes, any sport institute, any place visited by employees, a dwelling place or home, an unorganized sector. The Act declared in clear terms that no women shall be subjected to sexual harassment. The Act envisages constitution of Internal Complaints Committee in every workplace to be constituted by the employer. There is also the provision of constitution of Local Complaint Committee to be constituted by the district officer to receive complaints of the sexual harassment from establishments where Internal Complaints Committee has not been constituted. Friends, let us conclude. To conclude, various rights are conferred under the statutory laws for the benefit of women. The discussions which have been made are not exhaustive, but only illustrative. Various statutes of India regarding criminal law, property law, and personal laws made provisions for women. If not enough, it is the modern thought of the gender equality and to renounce practices derogatory to the dignity of women that various statutes appear in the recent years, covering various aspects of women that are left untouched, showing that arms of the law is very long and it can reach the domestic life to hunt out violence, if any, towards the women and to redress their grievances. There is another dimension of the sexual harassment in the workplace covered by the Criminal Law Amendment Act 2013 and the sexual harassment of women at workplace prevention, prohibition and redressal Act 2013. The fact remains that conferment of rights by statutes is not enough. The benefits of the rights must reach to the women. They must be made aware, and educating the men folk by means of education must be the need of the hour. The scheme of free legal aid would also be very much useful, as all women are eligible to get legal aid under the law known as Legal Services Authorities Act 1987. So friends, this much for today. Thank you very much.